Hello everyone, my name is Brandon Davies. I'm a criminal defense lawyer based out of Overland Park, Kansas. In this video, I'm going to talk about your average diversion agreement. Now to get this out of the way right at the start, this video is not an end-all be-all about diversions. This is not going to serve where a person should not talk with a lawyer or anything like that. This is just going to talk very briefly about some very common things that come up in a diversion agreement and why it may not be for you depending on your specific set of facts. Now I'm just going to go over a couple of common things that are in diversion. The first thing is going to be, obviously, it's going to establish what jurisdiction you're in, it's going to establish what crime you've been charged with, and then it's going to go into various different waivers of rights. Now, the reason that these waivers are in place is because a diversion is a contract. Just like any contract, you're going to give up certain things and the other side is going to give up certain things. Part of every diversion contract is going to make you waive some of your rights. Now, the reason they do that sometimes is for practical reasons, but other times it's so that it makes it very easy to convict a person if they violate the terms of the agreement. Now, I'll go over a couple common ones. The first one will probably be something to do with waiver of a right to counsel. In other words, if you're doing this on your own and you don't have the advice and assistance of a lawyer, it's going to make sure that you know that you have the right to have a lawyer, and it's going to make you waive that right. The reason the court's going to do that, the reason the diversion agreement is going to do that, is so that you can't come back later and say, well, wait a minute, I didn't know I could have a lawyer on this case. One of the other things that the diversion agreement is going to do is going to talk about waiver of a right to speedy trial. Now, the reason this is more of a practical reason. The diversion is usually a year long for most crimes, and one of the conflicts in that is that you have a right to have a speedy trial within 180 days of arraignment in Kansas. So if you think about that practically, if you're going to voluntarily continue a case out for a year is longer than 180 days, so you can't practically preserve someone's right to a speedy trial. Another thing that the diversion agreement is going to go over is going to be a person's right to have a jury trial. Now, in some municipal cases, you might not actually have a jury trial, and in some cases, you might not have a right to a jury trial, depending on the violation. But if it's a Class A misdemeanor or you are entitled to a jury trial, then the court is going to notify you that you have that right. Again, it's so that you can't come back later and say, well, wait a minute, I didn't know I could have this trial in front of a jury. In the diversion agreement, it's also going to make you waive your right to confront witnesses and testify on your own behalf or present evidence on your own behalf. Now, practically, if you do a diversion, you are essentially giving up your trial rights, all of your trial rights, so that's part of the exchanged for bargain when you sign a diversion agreement. Again, you're giving up some rights, they're giving up some rights. But when you waive these rights, you can no longer have a trial, you can no longer present evidence at that trial, like testimony on your own behalf or testimony of other witnesses or experts. You can no longer confront witnesses, so you can't question the cops or any other law enforcement officer that makes some sort of allegation against you. All those rights are waived when you sign the diversion agreement. So, to this point, we've been talking about things you've been giving up. Now, there's another pretty common thing that's in a diversion agreement, and it's going to inform you of your right to have a trial upon a violation. So what that means is whenever you sign a diversion agreement, you are saying, on the facts of this case, I'm never going to have a trial. I'm going to stipulate or agree that I violated the law, but I want you to give me, in exchange for my stipulations and agreements, I'm going to get a period of time in which I'm allowed to complete certain tasks or keep up my side of the diversion agreement. Whether that be do alcohol and drug classes or things like that, or whether it just be refrain from any new law violations. So you're waiving all of your rights to actually contest the charges on this case. Now, if you have some sort of problem while on diversion, say the city believes that you have violated the terms of that agreement, then you can have a trial upon the violation. No diversion agreement can make you waive your right to have a trial on a violation. But you have to remember there is a different standard of proof whenever the city is trying to prove you violated a diversion agreement. One of the last things that's going to be in virtually every diversion agreement is, like I referenced before, a stipulation to the facts. Essentially an agreement that you have violated the law. You're going to stipulate to police reports, videos, statements, that those can all come in against you if there ever is a trial on stipulated facts. This makes it very, very difficult for you to defend a case if you are found in violation and you have to present a case based on stipulated facts with no trial rights preserved. As you can probably tell, a diversion agreement is a complicated legal document with all kinds of in and outs. If you have questions about diversion, if you are involved in a criminal case and you're thinking about whether a diversion is for you, feel free to contact my office.